Everybody's quiet, so when you start. All right, welcome. And I think, Julie, I think it's 10 years now for you're signaling me. Can you not hear me?
Microphone, yeah, please.
It's on.
It's on, yeah, if you could just speak closer to it.
All right, Julie, I think it's 10 years, right? The Children's Commission.
It will be 10 years this next summer. We're in our 10th year right
Okay,
now.
excellent. I know, isn't that something? Some of us have been here since the beginning, so thank you all, and welcome to all you that are here and those that are watching us live stream or will watch us later on video. This was a particularly tough day to set a meeting because of conflicts across the board. I will say in my 10 years of serving on the Children's Commission, attendance has been outstanding. I would say probably averaging 85 to 100. And these are all the people that are on the Children's Commission by statute, or sort of the policymakers within their branch or within their agency. So thank you all for coming. And we'll start off with a consent agenda, which is the minutes from the October meeting. Any changes or additions to those minutes?
And Chief, you may want to put off the items that require a vote until the rest of our members come.
I can't hear you. You're echoing.
Sorry, you may want to put off the items that require a vote until the rest of the members arrive.
All right, so we're going to move the plans around. So do you want to skip? We're not going to skip Jared Wilson's foster success, but that being an action item, do you want to go down to strategic priority?
Yeah,
All right, so Susan Ellsworth from the Mental Health and Substance Abuse will give a presentation on the needs assessment findings for children and youth with fetal alcohol syndrome. So Susan Ellsworth, welcome.
Thank you. All righty. So I am, let's just put this right in front of my mouth, right? So I am the founder and recent executive director of Indiana Alliance until November 1st, where I became full-time staff at FASD United on the national level in Washington, DC. I was a foster parent for the state of Indiana for 12 years. During those 12 years, we adopted 9 children, 5 had prenatal alcohol exposure, and this is what brought me to the world of FASD. So today I am here to share with you the results of the statewide needs assessment that we did and the overview. Generally speaking, I wouldn't be someone who would be reading from the slides, but in order to keep fidelity with what you would find if you actually read the version of the report, the recommendations are word for word.
And this starts on page 9 of the handout that you have before you.
So the needs assessment was completed on September 30. It was disseminated across the state electronically, had 2 versions, one for providers, and that's all kinds of providers, whether those were medical, mental, health providers, clinicians, case managers, and then one for individuals and families. And it was prepared by BBC, which is connected to Emerald Consulting, who did the first statewide needs assessment in 2006. Indiana Alliance received grant money from DMHA. We oversaw the needs assessment. So in our needs assessment, there were items that came up that they called discussion items and recommendations. And the first one was that the electronic surveys may not be the best vehicle to solicit participation with people with lived experience. I would add that a caveat that probably not surveys in general. We can't make that assumption because our survey was done electronically, but the capacity for them to keep track of the questions all the way through and follow through was very challenging for them. So the proposed action step would be to build personal relationships to learn more about their experience and how best to capture their input. Because I'm sure that you're aware that sometimes in committees and high levels, we get together and we talk about people in a group and what we perceive their needs to be. We formulate a solution to their needs, and then we send it out to be implemented. And when it gets to the people that we're trying to serve, we find out that that really wasn't their need or wasn't very helpful at all. So actually getting their input and bringing them to the table is critical. The next item was awareness about healthy pregnancies. The survey showed us that there was improved information about what would be related to a healthy pregnancy. However, some respondents still do not believe that wine is harmful. And 24% of our providers said FASD can occur if the pregnant person drinks certain types of alcohol, not any kind of alcohol. So the proposed action step is to expand public awareness and effort and education about potential harmful effects of any alcohol consumption by pregnant people. The next item was the alcohol consumption during pregnancy. Our survey indicates that increased consumption during pregnancy, both the 3 months prior to pregnancy and during an average week in the past month. So the proposed action step would be that there is a need for ongoing education about consuming alcohol during pregnancy and to address popular beliefs about occasional drinking, that some types of alcohol, wine and beer, are acceptable during pregnancy, should be addressed. We still have pregnant people telling us that their OBGYNs are telling them that a glass of wine every now and then is not harmful, or light drinking is not harmful. And so even though the messaging has changed, it's going to take a while for that to trickle through so that all of our providers are staying on board with standardized messaging. The next one is understanding FASD. So data suggests that there remains a continued lack of understanding the criteria for describing and diagnosing of FASD, and the action step is ongoing and expanded public awareness and education about fetal alcohol spectrum disorder aimed at the broader community is necessary, and information and training should be targeted to both the general population, especially pregnant people, their families, as well as providers of all backgrounds. The next item is screening. Results of the assessment suggest a general lack of awareness about purpose, availability, and utility of screening tools. So I think one of the things that we learned through IPQuIC is that providers were continually asking for, we need screening tools, we need screening tools. And what we found is that there are evidence-based screening tools out there. The real issue is their uncomfortableness about having this discussion with their patients. How do I talk to them about their alcohol use? How do I let them know? So the proposed action step is information and training for providers about availability and accessibility of screening tools should be included in awareness and education efforts. Policymakers may want to take a look at considering ways to encourage the use of screening tools to identify pregnant people and children at risk for alcohol exposure. Okay, so the next one deals with the registry, and the results of the assessment suggest a lack of knowledge among non-medical providers about Indiana Birth Defects and Problems Registry. And this is how Indiana determines its prevalence for FASD. And I don't want to go too far in the weeds here, but I do think we want to just take a pause and talk about why that this is so critical, because FASD is not a diagnosis. It represents a spectrum of diagnoses. And so we are more comfortable and aware of FAS and familiar with those ICD-10 codes. But what happens is for there to be an FAS, we have to have confirmed alcohol use, and we also have what we call phenotypes or facial features. So if we think about the journey through pregnancy, we still know that about half of the pregnancies in Indiana are unplanned. And so it's not that alcohol exposure is always intentional or irresponsible. It's that people who aren't expecting to be pregnant are not finding out until 6 or 8 weeks after conception that they're pregnant. So we think about the journey through pregnancy, we get to the end, and then we've gone through 9 months of adjustments and everything that means being pregnant. We've gone through a labor process, and now we're going to have someone come in with a survey of 40 to 50 unrelated questions and ask us these questions after delivery. So the person who's answering the questions may not remember that there was alcohol consumption before they were pregnant. They may just be tired. They may be very aware that there was alcohol consumption during pregnancy, but they know that they're in a hospital. They're in a situation where they may get a visit from a social worker and potentially a fear of a DCS worker if they were to say yes. So without those facial features and without notes in a patient's chart that there's suspected alcohol exposure, then infant parent leaves the hospital, and then they start noticing things being slightly off or challenges later on. And our issue currently with this is our birth defects problems registry picks up diagnoses on age 0 through 5. So anytime that there could be a diagnosis after the age of 5, which is when most diagnoses are made, it never ties back to our prevalence rate. And we already know that this is underreported. So we're looking at getting this changed to going back to age 0 through lifespan. So the proposed action step here is additional research may be needed to explore the best ways to identify and document prenatal alcohol exposure, to support accurate diagnosis across the lifespan beyond age 5, and to inform necessary and appropriate services for people diagnosed with FASD. Agency leaders and policymakers may want to consider how data collection can be improved and how data can support the planning for services and programs to meet the needs of people with FASD, their families, and communities. The next item is resource sharing and education materials. The needs assessment results suggest ongoing need for demand to provide current resources using preferred information access methods and target audiences. And the action step is to explore ways to share more information digitally through websites, social media, and apps, in addition to traditional brochure and print materials. Next item is the continued effort around FASD. The results of the 2022 needs assessment echo the findings from 2006 regarding the need for coordinated approach to the complex issues of FASD. And the proposed action step is to establish a statewide FASD task force with appointed membership representing people with lived experience, providers, agency leaders, associations, content experts, and policymakers, supported by a paid coordinator to oversee the following: respond to the needs of identified in the FASD needs assessment, oversee a comprehensive public health awareness campaign, collect data to inform education policy efforts, coordinate with appropriate agency partners, associations, and community leaders, make recommendations about policy programs and services, and report regularly to the policy and the community. So, closing comments. The FASD subcommittee will be submitting official recommendations regarding evidence-based programs to address mental health and behavioral concerns for individuals with prenatal alcohol exposure in the coming weeks. And I would also leave lasting parting comments to you that prior to 2019, the CDC told us that 1 in 9 pregnant people confirmed alcohol use during pregnancy. That is now 1 in 7. It's going the wrong direction, with 20% of pregnant people reporting binge drinking. You also need to be aware that at the beginning of February of 2020, the NIAAA did a study where they had a cohort of pregnant individual or of women at beginning of February of 2020. They resurveyed the same women in November of 2020 and found that drinking for women exceeded recommended guidelines by 53%. And women with the age, school-age children under 5, drinking rose 323% during the pandemic. This is not going away. This is a universal problem that touches all of our disciplines. 1 in 20 school-age children are believed to have been exposed to alcohol. That means that's in our neighborhoods, in our schools, and all of our programs, and they're showing up in our juvenile justice systems and in DCS cases. So with that, that would conclude my report on our needs assessment. I think Julie has the actual entire needs assessment that she can distribute to you electronically. This is my contact information. And if you have any questions for me now, I'd be happy to answer those for you.
I have a question. The FASD subcommittee, they're going to continue to meet, correct?
I think that we are continuing to meet until the recommendations are made. I'm not sure that it's clear whether that's going to be ongoing or not after we meet the outcome.
They have action items, Julie. Is that going to get on another agenda for the full commission to vote on with regard to looking at a subcommittee, changing the data collection ending at 5, with regard to the recommendations?
Yeah, so two different things here. Yeah, Susan said they're gonna make some more formal recommendations that can happen at the February meeting. And then whether the commission wants to take on sort of that recommended task force as an item moving forward depends on if we want to go ahead and put that in the next strategic plan. So I think if there's an interest in the commission being the entity to kind of keep that work moving forward, we can certainly include that in the next strategic plan. Like Susan said, it's relevant to all of the populations that we work with. And in particular, I'm really interested in the connection with juvenile justice and the behavioral implications, right? When we don't catch those kids early and figure out how to help them. So we can include it in the next plan.
Yeah, this might be a question for Dr. Box, but I had a lot of children with fetal alcohol syndrome, a lot of drug exposed, but you don't really connect them. Fetal alcohol syndrome is like a different entity than the children that are drug exposed. And this is just anecdotally sitting on the bench, tens of thousands of cases. The kids with fetal alcohol syndrome had even more challenges in my court than kids that were drug exposed. You hate to just look at that, and the diagnosis didn't happen by 5. They would show up in reports when I get an evaluation. You probably see it, Chris, at DOC, the number of kids that are that have significant challenges given FAS.
Yeah, I think that's a really good point. I think Susan made excellent points today with a great presentation. And, part of this is that providers in the past have said, a glass of wine's not going to hurt you. It'll relax you. It'll prevent you from having contractions. That has been changed and the wrong message for so long, but we still have providers that say that. There's no training going on right now anywhere that I know of that would train that that's appropriate. So when we get some of these older physicians now and clinicians, that may improve. Sorry to say that because I'm one of those, but I've never said that. I think importantly, IPQUIC does support in 77 out of our 80 now 3 delivering hospitals a substance use disorder, which includes alcohol syndrome. But unfortunately, our screen, if you screen for drugs, it's a certain cost. If you add alcohol screening to that, it adds $45 to the screen. And that screen is being absorbed by most of our hospitals across the state.
Are they screening most babies for, no, just
So
unless
only
there's
a handful of hospitals are actually screening for alcohol at the same time. Now, there's testing screening, looking at someone's urine to see if it's there, but there's verbal screening. And we've had that in statute now for several years, that you have to do verbal screening for substance use
But
disorder.
that's at the tail end. That's after the damage is done.
No, it's supposed to be early in pregnancy.
Okay.
The ideal would be preconceptually, right? That we actually see women and talk to them about these habits beforehand and address those things so they can, not conceive and maybe miss their period or not really realize they're pregnant and find out they've been using alcohol this time. But realistically, fetal alcohol syndrome is alive and well. And as you said, actually increasing. We saw substance use disorder and everything increase during the pandemic. So IPQUIC does work on this, but there's not been a set recommendation from ACOG or anyone else that all women should be screened, regardless of what they verbally say about the use of alcohol or drugs, that all women should be screened. Now,
Do you find that the children that appear, and again, there's a range, I'm sure, but fetal alcohol syndrome presents some of the toughest challenges,
so
emotionally, psychologically?
here's what I'll say to you. it's pretty rare to have a baby delivered and look at the baby and go, oh, this baby has fetal alcohol
Right.
syndrome, right? That can happen, but it's usually not the case. It's usually more the pediatrician or family doctor that's following this child up, and maybe the developmental, goals are not being reached, or that child has issues with their control and other things, ADHD and ability to, kind of focus. But what we're also seeing is that people are like, oh, okay, I won't drink, but what I'll do is I'll smoke marijuana or I'll take marijuana, and that has increased dramatically. And they think that's safe. And really, if I had to choose opioids or some of these other drugs people would use, I probably would choose that they not use the marijuana, because we have more evidence that that's an issue. So the bottom line is substances in pregnancy, even preconceptually, are not a good idea, period.
When we look at sort of healthy pregnancies, and this issue has to land somewhere. This has to be somewhere, because it's not going away. It's,
You're right.
and it's rough. And, I, met with lots of foster parents who got really the diagnosis didn't even come till they were in foster care, and the foster parents brought it to the attention. But, I would like to, move ahead with this and see some recommendations that the commission would vote on. Now, paid coordinator is out of my bailiwick. I don't have the power of the purse. But I definitely think whether somebody could be, maybe there's somebody already embedded is there somebody embedded at FSSA that's working on fetal alcohol, or?
So they would have their disabilities, individuals with disabilities, and we have the Indiana Perinatal Quality Improvement Collaborative, but that is really about, that pregnancy and first years of the baby's life. But we certainly do we have expanded quite a bit since they were originally formed with levels of care. But this is something that we probably ought to talk to Indiana AAP about too, to see where this entity would best lie.
Your Honor, I think the reason why the task force becomes so critical is because it crosses Department of Health and DMHA and Juvenile Justice and all of those. And what happens is inside Department of Health or any other places, there's a person assigned to oversee it, but they're assigned several other things. And so what we need is someone on point whose focus is this topic, so that it doesn't get lost on the plate. And if I could for just a second, corroborate what you're saying, our son, who now is 16, going to be 17 in January, at the beginning of the pandemic, he had supports in place. And he had built those up. But when we got COVID, there was nobody coming in, nobody going out, and we were sheltered at home, and he was cut off from his supports. And he probably has more of the severe behaviors that can accompany an FASD. The wheels fell off for him. And so he went from being threat to harm self to threat to harm others. And from the March of 2020 through October of 2020, we had 4 ER visits. We had 3 acute stay, a 4-month residential stay, and he's now on 17, almost getting his footing back underneath him. And during that time period, I know how to navigate systems because I work with systems, but most parents don't. And our family was bounced. We were bounced from, physical, physicians from from physical health to mental health, who said that they could only make so many recommendations and open so many doors with what they had available to them, to referring us saying that we needed a Gen 6 file so that DCS could open doors for us. And then it was like, oh no, you just call the police every time that he gets violent and he's hurting somebody. And so we were bounced. This needs
That's
to
a similar story.
Well, I'm
That's-
sorry, this needs to be owned and everybody work
Right.
together so that the families get this.
And Corey's here from probation. I can't tell you how many pre-sentence reports I've read where it said suspected fetal alcohol. How many, lots, a lot of kids in the system and adults in the system. Well, wonderful presentation. Any other questions with the commission? I mean, I'd like to see us vote on some recommendations.
Thank you for your time.
Thank you. All right, Let's have the presentation on juvenile justice and cross-system youth. I've got Judge King here from Ripley Circuit Court, along with Waylon Jennings from DCS. We'll talk about juvenile competency legislation taking effect December 31st, which kind of feeds a little into what we just talked about, I'm sure.
Yeah.
All right. Thank you for having me here today. I'm here to talk about the new juvenile competency law. It's going into effect on December 31st of 2022. And it's probably time that we actually do have a juvenile competency law. Many of us have been struggling with competency issues with juveniles for a long time.
Judge King, for
has
some of the
not
people
happened.
watching or in the audience, a lot of us know it, in the legal field, know what that means, competency. Can you just give us a little overview to give us what juvenile competency law is?
As far as the juvenile competency and what competency would be, it's a legal concept. And it's a legal concept that would be particularly important because all people need to be competent, whether they're an adult or a juvenile, as a matter of due process before legal proceedings or substantive legal proceedings should begin. And when I say competent, and we'll get into that a little bit later, but they need to understand the proceedings and the objectives, and they need to be able to assist their attorney. If they can't do those things, then they're incompetent, and we'll see what that may entail later on in the presentation. Did I answer your question?
Yes, thank you. Thank you, Judge.
And particularly, I'm here on behalf of the work group. I'm chair of the work group, and here are several folks from different disciplines that are part of the work group. Dr. Coley, Judge Murray, Magistrates Van and Magistrate Pappas, Joel Weineke, Tracy Fitz, Susan Lightfoot, a probation officer, and of course, Don Travis. The next set of folks have done a whole lot of lifting. That is Jeff Berkowitz, Angela Reed Brown, Mindy Pickett, and Nancy Weaver. In particular, Jeff Berkowitz, Angela Reed Brown, and Mindy Pickett have assisted this work group in a very, very significant way because the statute is cumbersome. And to try to dissect it and break it apart and to apply it is exceedingly difficult. And those folks have really been helping the work group a lot. The issues are what we looked at as far as the work group goes. There are three main issues that we've looked at thus far. And when I say thus far, so far we've had 4 meetings: October 11th, October 25th, November 22nd, and December 6th. And we have 3 additional work group meetings scheduled for January 3rd, January 24th, and February 7th. So this work group has been very busy. But what we've been working on so far is the competency evaluation report, what that report looks like when you get it from an evaluator. And we'll get into what an evaluator is here in a moment. We've also been working on a timeline or a flow chart. And we've also been working on forms, judicial forms of appointment of evaluators, judicial appointments or judicial forms on ordering probation to provide information to the evaluator, as well as what I would call dispositional forms as it relates to the competency issue. As a way of background on the statute, it is essentially comprised of 2 separate things. The first one is the evaluation, which is the process of determining whether the child before the court is either competent or incompetent. And then the second, which Waylon will be primarily addressing, is the attainment. And the attainment is the process of, in the event that you have a situation where the child is incompetent, then how do you go about providing services to that child to make that child competent before proceedings begin, if possible. In Indiana, the evaluators must be a psychiatrist or a psychologist certified as a health service provider in psychology. That's a lot different than other states. Other states will permit other mental health professionals to do a competency evaluation. The statute in Indiana does not. And it states that the court shall appoint one and may appoint a second if a party requests. And not only do they have to be a psychologist or a psychiatrist, but they also, and this is important, need to have expertise in juvenile competency. You'll find that there's probably a lot of psychologists out there, but not necessarily that have expertise in juvenile competency. The first issue we addressed was the contents of the report as a worker. And in doing that, we looked at what other states have done. Other states, some of them have almost a checklist, a very rigid formal document that says you'll do this step, this step, this step, and this step. And we as a work group and upon advice of Dr. Coley took a different approach, although other states take the same approach that we took, where we basically break things down into several subject matters. And then it gives the expert or the evaluator discretion then to address each of those subject matters. The first subject matter is a detailed identity of the juvenile. What are the charges? Where's the date and the place of the evaluation? The purpose of the evaluation. Again, of course, the primary purpose of these evaluations is to determine competency. But there's a secondary purpose for these evaluations as well, especially as it relates to those that are incompetent. And that is what sort of services would the evaluator recommend if indeed this child is incompetent. The third subject matter is a list of the information considered. And that is what it says. It's just a list of the information considered. Generally, that's of course, an interview of the child, other interviews of other folks that know things about the child. PI stands for preliminary inquiry, provided by probation, other records, and or psychological or forensic tests. And again, that is the list portion. And the next subject matter is the relevant history of the juvenile and of the matter. And for instance, something that you might find to be relevant history and should it be included in a report is perhaps the child has traumatic brain injury. Or something else that would be relevant is what brought this issue now before the court? You know, I mean, was it the child's behavior in the courtroom? Was it the child's behavior with the defense counsel? Or perhaps it was the child's behavior during the investigation. So that would be relevant history of the matter that the evaluator will really need to know and be able to flush out. The mental status is pretty, I guess, is what it is. It says it is. It's the IQ. There's several different things that would be considered there. But for instance, it's an IQ test, for instance. It would also be psychological tests, forensic tests, how the child currently presents before the evaluator. Is the child cooperative? Does the child have other diagnoses? In many of these reports, you will find a diagnosis of the child. If competency becomes an issue, many times you will see schizophrenia, bipolar, schizoaffective. I mean, there's many times a clinical diagnosis. So then that's where that would be included. And malingering, that's a big word. Maybe some people know what it is, at least on this panel, but the general population probably would not. It's basically faking it or embellishing it, which can happen, but then that's an opportunity for the evaluator to then offer their opinion as to whether that's happening in a particular case. And then the last subject matter is the expert expounding on the issues related to competency. This is maybe in the legal profession, we almost refer to as their argument, their synthesis, their analysis, or their reasoning. And then the last portion is the part that is set forth by the Indiana statute. And is the thing that Justice Rush was just asking about. Really, what is it, right? And then the evaluator then has to make a clear statement as to whether competent or incompetent. And the test in Indiana is whether the child is able to understand the nature and objectives of the proceeding and whether it's able to assist in his or her defense. Now, That's a little bit different than the Dusky standard that you'll find, or stated a little bit different than the Dusky standard that you'll find as it relates to adults. I don't know how it will be interpreted. If it will be interpreted to be a little different, but the Dusky standard does not include the words and objectives. So I think we in Indiana wanted to make sure that the child was more understanding of what this was all about, perhaps what they were facing, what the legal ramifications may be. I don't know. I just found that interesting that language is included in our statute. If the child is not competent, then the evaluator then would give a recommendation as how attain the services. How perhaps can this child be made competent? And that is the first subject matter that the work group dealt with. The contents of the report. That's what we as a committee recommend the contents of the report should be. And that's what we are recommended should be submitted to the court. The next issue, the evaluation and timelines. As it relates to timelines, this is where I refer to the flow chart that the Office of Court Services, specifically Jeff Berkovitz and Angela Reed Brown, have been working tirelessly on. It's currently 4 pages long. It is a very in-depth flow chart that includes timing elements. And for me to go step by, it would probably take 20 minutes just to go over the flow chart. So I'm going to hit some of the highlights here, and you'll find them in red, except for the first one. And this is very important. Everyone should treat the matter as time is of the essence. That's for the judge to treat as the matter is the time of the essence, for the evaluator to treat it as time is of the essence, for the parties to treat it as time is of the essence, because without even going through the rest of it, you're dealing with the child. So you need, that's not something to sit and forget. It needs to be top of mind. So that's the number 1 bullet point. Secondly, there's a lot of different timing elements in this statute, maybe more than almost any statute I've seen, but generally they're maybe not as, there's a couple omissions that I think might be as significant as the actual timing elements. The 7 days, for instance, 7 days for juvenile probation to provide the information to the evaluator. That's where the 7 days come from. 14 days, as you can see from the slide, after the evaluator has done their evaluation to generate the report. Okay, but what the statute remains silent upon is the actual time it takes the evaluator to do the evaluation. And what you will find there is you will have a wait list on many psychologists and psychiatrists' calendar, and B, it does take considerable time to do a good evaluation. And that's important for the judges and for parties to be very cognizant of, and referring back to the first bullet point, that you need to know that and maybe set a time frame yourself if you're the court. Maybe it's 30 days, 60 days, something with a quick turnaround. And then another timing issue that we found as a work group that could be, it's a little squishy, is it says as soon as practicable, the court shall determine competency. Well, what if a hearing is required? That could be the case. Maybe a hearing is not required. Maybe the parties stipulate to the evaluator's findings. But if it's contested, again, you're dealing with setting a hearing where someone that's very busy can be present at, right? The evaluator, maybe you even have 2 evaluators. So again, that becomes another issue where I would refer back to the first bullet point, where time is of the essence and these matters need to be handled with priority. And as in the adult law, there is a year basically where the case has to be disposed of unless there's certain things, continuances on behalf of parties or on behalf of the defendant. The juvenile law is much the same. There's also a year time frame in which it needs to be brought to a conclusion. So again, another reason to always keep it front and center of mind. But as I said, those are just some of the highlights of this flow chart. It is very extensive and a very good work product. The order forms. This is the third subject matter that the work group dealt with. And so far, we're in the process of drafting multiple order forms. We worked on these yesterday as well. There, of course, there's going to be an order appointing an expert. There might be an order appointing experts. And why I say that is it depends upon if it's a very significant waiver type case. I would suspect, I would want to get everybody in at least on a pre-trial and say, hey, is this a type of case we want to go ahead and appoint two experts ab initio right from the start? Because I suspect that whoever, if it comes back as incompetent, then maybe the state would say, well, I want a second opinion. If it comes back as competent, then the defense or the juvenile's representation may want a second opinion. So that's why I put, or perhaps experts. The second one is an order, as I spoke about previously, to probation to provide documents to the evaluators. And with that includes a bit of a corollary that we have as a work group spoke quite a bit about. And it would be an order to the parties to provide what they believe is important for this evaluator to consider. So that way, everything that the litigants believe is important can be considered by the evaluator up front, as opposed to, for instance, on the witness stand through cross-examination and that sort of thing. So we want to provide all the information as best we can, as soon as we can. The next three things are, again, what I would refer as dispositional in nature, a dispositional of at least the competency issue. The first order is order finding competent. That was easy, right? The order finding competency, finding the juvenile child competent and then proceeding. The second is when it gets a little more interesting. And I'm going to generalize just a little bit here. An order finding incompetent, but not able to obtain competency. And here's the generalization, because if you read the statute, it's very, very detailed. But the generalization I make is generally that the attainment process will take 180 days on a felony and 90 days on a misdemeanor. Now, there's a little bit of variation in that statute, but that's a good rule of thumb. And on the second one is if that determination could be made up front, if you will, before attainment services even begin, you have two evaluators that say this child will never obtain competency within 180 days on a felony, and you're the court and you listen to the evidence and you think the same thing, then the case is dismissed at that point in time. And we'll get to that and what happens upon that dismissal in the next slide. The third is where the attainment proceedings with the Department of Child Services that Waylon will speak about occur. Because and that part of the statute, and I think that's the real meat of the statute, if you will, is where you find the juvenile child incompetent, but may obtain competency within 180 days if charged with a felony, or 90 days if charged with a misdemeanor. And that is the situation that you then would refer to the attainment service provider, which is set up by the Department of Child Services. And if the child does not obtain competency within those timeframes, what happens? It's a dismissal. And under the statute, it's a dismissal. It can either be a dismissal now, or it can be a dismissal later. That's basically what it says. But they are dismissals without prejudice. So, and maybe I should explain that a little bit. A dismissal with prejudice means it's over, done with, concluded, never to be heard of really again. A dismissal without prejudice does not mean that. It means it can be refiled. So, but that's one of the avenues. And then the second one would be a delayed dismissal for 90 days. And then that's when it would be referred to, and what several of the folks call it, the off-ramps that are built into the statute. Where the child was unable to the child went through the attainment process, was not successful, spent 180 days and perhaps in a residential facility, did not obtain competency. then the case could be dismissed and then referred to these other entities. The first one is the Department of Child Services for assessment as whether the child will be a child in need services. The second one, although I don't know if this one will be as successful, to the DMHA or to the BDD, Bureau of Developmental Disabilities, but neither one of those, it's also in the statute, but neither one of those entities have an obligation to provide services. So I don't know how far that was going to go. I mean, that one kind of left me scratching my head a bit, but the third, the language in the statute says otherwise secure services, probation shall otherwise secure services to reduce recidivism. Now that would mean to me probably a community partners referral, maybe even perhaps an informal adjustment could then be agreed upon at that point. I think that's what that says, but it just says otherwise secure services. And that's what we as a committee had discussed as being potential outcomes there. And then the fourth one is the civil commitment. If the child is mentally ill, if the child meets the statute for civil commitment, then proceedings could then begin there. So those are the off ramps. So it's not just, I mean, it can just be a blanket dismissal without prejudice, or, you know, it can also be one of these off ramps. And this quote is by me because I thought at first time I read it, I thought there's a lot of dismissal probably that very well could happen. And then what? You know, and I think it's important to notice, since I just spent probably 5 minutes talking about dismissals, it's important to note that the statute does allow these matters to be refiled. That's the section there, 31, 37, 26, 6M. And then there's another part of the statute that says the petition is deemed to be filed at the time the child is found competent. So there shouldn't be timing issues there either. And I think that's important to know. That's my reading of the statute. So when there is a competency issue and then there is an incompetency finding, then it appears to me that, you know, it's not necessarily barred forever. And what I think will end up happening in practice, having, you know, and this is just me kind of thinking through these issues, is what we're probably going to have is a lot of the lower level, you know, the parties and or the state may be looking at these matters, especially like on a low level offense where a child was found incompetent, went through 180 days of the attainment process, and then was referred to one of the off ramps. Is that something that they would want to refile? You know, I've done this for a while, so I don't know that there might be some real consideration given, and that case might not be one to be pursued any longer. Of course, it would be case by case, but the other issue is maybe on the presumptive waiver cases, then those would be the type of cases then that, you know, I would think people would keep tabs on. They would look at those cases and see if that juvenile or if that child later attained competency. And if so, then they're not prejudiced at that point. They're not, you know, out or timed out. Then they can bring that charge then later. So it will probably have the net effect of removing some of the lower level offenses from the criminal justice system, which I think most of us would agree would be a pretty good thing.
Does the judge still have the authority to, before you file a new delinquency petition, the judge has the authority to find that it's not in the best interest to file it? Don't you still have to do that approval? So the judge can serve as a gatekeeper on some low level one if there's going to be repetitive filings on a severely mentally ill child.
Not surprisingly, that's absolutely correct. So let's say the state determined they wanted to go forward and you as the trial judge said, well, we've already been through this. You would have discretion to say, well, I deny your petition to file this formal delinquency petition. I deny your formal delinquency petition because, and you could probably say, well, the child was previously charged. The child was sent through 180 days of attainment proceedings. The child was referred to the Department of Child Services. The child was, I mean, I could certainly.
Perhaps at that point, the child is a chin 6. And I know we're going to have another presentation from DCS.
Please.
And perhaps the child's a chin 6.
Right.
Better in the welfare system than in the delinquency.
Absolutely. Yes. And that's one of the off ramps, I think, to be more specific. When I referred to the DCS for the assessment, I think most of those would probably be the chin 6 statute.
Any Anything else? Judge King? Any questions from the group? It's a very thorough presentation. Are you presenting to the juvenile judges on this too? or-
Yes, last meeting, I spoke briefly about it, but not probably go as in depth as I did here today. Because again, this is kind of still a matter, I mean, we're still very much in work group. There's none of these, the report's not set in stone, the forms aren't set in stone, it's at least from our final.
Just an update.
Yeah, we're just kind of in the drafting process, and hopefully as things continue, the product will continue to get better and better.
Well, thank you. Any other questions? All right, so are we gonna hear from Waylon James then for
Thank you.
DCS to talk
Thank
about?
you.
Thank you, Judge. Competency attainment services.
Thank you, Judge King. My objective today is to speak about the competency attainment services. There we go. So the Hoosier children are guaranteed the right to due process in a fair trial. These are some of the, these are some of the goals that's been set out for the competency attainment. The next one would be the Hoosier children are restored to competency whenever possible. And the children understands the legal process and the nature of their offense and is able to assist in their own defense. The next one would be services are provided in the least restrictive setting, possibly based on the children's needs and the safety of the child in the community. The service provision is individualized to the needs and development level of the child, because we'll have different children that will have, of course, different needs that come in. Our department did an RFP, and we had a couple of different providers. 2 providers were selected. To do the competency attainment services, which was Damar and Syra, and both of them have made a commitment to serve all children statewide. So some of the things that with the competency attainment will be looking at the eligible population of these children that are deemed not competent to stand trial in accordance with Indiana code and referred for DCS competency attainment services. As I mentioned, these services must be offered across the state. Both of the forgot to mention, both of the providers are based out of Indianapolis, Damar out of Indianapolis, and Syra out of Carmel. Competency attainment services in the least restrictive setting that is not consistent with the child's ability to attain competency in the child of both the child and the community. And the providers must have experience providing competency attainment services. To my knowledge, Syra has done some work with competency for adults.
Just like you mentioned Damar, what was the other provider?
Syra, SYRA. Yeah. So, so some of the curriculum that that we're expecting to have is the contractor shall provide individualized in-person services unless a virtual meeting is required for health and safety. And any virtual meetings must be approved in writing by the probation department. The contractor's competency attainment curriculum must be approved by the state prior to the initial provision of the services. And the curriculum shall include comprehensive instruction about the delinquency trial process and the child's legal rights in a delinquency case. The curriculum also shall include an assessment of the child's ability to connect their understanding of prior behavior with the potential consequences of this behavior to help bridge a gap in this understanding. So additional supporting services in support of the DCS curriculum, contractors shall also provide case management services and coordinate with other entities to provide mental health services and medication management. So I think that's a real important piece, that they're going to have to do all these extra things and to be able to help that youth. In support of this service, the contractor shall also coordinate with other entities to provide medical, therapeutic care as necessary to provide these services directly. And the contractor also shall provide competency attainment services in the community detention centers and residential treatment facilities. As I spoke earlier, one of the things with Syra, they're kind of like a mobile unit. Well, they'll go to detention centers, other community settings and those things to be able to provide those services across the entire state. The contractor shall also be expected to collaborate with necessary and maintain a cooperative relationship with the other contractors. So everyone has to play nice. So notifications and requirements to the court. So the report of the child's progress every 30 days upon service termination through the individual monthly progress reports. We believe that the reports will look similar to what like residential providers provide now or service providers, but those are going to be tweaked to look like maybe, something similar to the adult reports, or we can also get feedback from the courts to be able to look at what they want those reports to be able to look like. We have a meeting also this Friday to be able to discuss the reports and to kind of kick off some things, which I'll speak about in a minute. If the contractor determines that the child could receive services in a less restrictive setting, contractor shall report this to the court within 3 days of the determination. So also the contractor determines that the child has achieved the goals of the competency attainment plan and understands the nature and objectives of the proceedings, can assist in their own defense. And the contractor shall report this to the court within 3 days, once again, of the determination. The contractor also determines that the child will not achieve the goals of the plan within the acceptable time period. The contractor shall report this to the court within 3 days and include recommendations for services that supports the safety and the child within the community. And as I've mentioned here, the two names of the providers that will be providing that service in our state. Our goal is to have this go live by December 30th. And we'll, continuously having meetings leading up to that just to be able to prepare for that kickoff. That's it.
Wonderful presentation. Any questions? Very thorough. I look forward to this getting implemented in place. Any questions from the commission? All right, thank you. Julie, what I'd like to do is go to, and I realize we're one shy of a quorum, but what I'd like to do is have the presentation. I think this is such an important issue, the recommendation to implement automatic enrollment in 21st century scholars, and then ask for the ones that are not here to vote electronically. So if we could have a 10-minute presentation from Jared Wilson to, I just bet your time, but I already said it was important, so I put my thumb on it. Presentation on why it's important, why you would like the, and I think, does everybody know what on the commission understand what the 21st century scholar program is? We're all familiar with it. Why do you think it's, and I know it's been part of other branches recommendation, and why would you like the children's commission recommendation? Because I'd like to, even though we don't have a forum today, I'd like to submit it to the people that are not here and ask them to vote electronically so we could get this done. So the floor is yours, Mr. Wilson.
Thank you. Good morning, everybody. My name is Jared Wilson. I'm the Senior Director of Education and Workforce for Foster Success, which is a nonprofit based in Indy, but works statewide on a lot of different success factors around foster youth coming out of the system. I serve as the co-chair of the Educational Outcomes Committee, and my co-chair unfortunately was pulled to Washington, D.C. for a meeting for this past couple of days. So here I am representing us together. So by myself, I guess. I'll briefly, since most people know the 21st Century Scholarship and the rationale behind why it was there, I'll kind of skim over some of these pieces real quick. So the 21st Century Scholarship has been around for about 32 years. It was established in 1990. The main goal of it is to help increase Hoosier students' aspirations and access to higher education, specifically low-income students. Students are eligible to enroll in 7th or 8th grade. There is one caveat to that, that if they are enter the foster care system anytime between 7th grade and 12th grade, they're eligible to enroll within the program. And we'll talk about that a little bit here in a bit. So essentially what happens with the 21st Century Scholarship is students who fulfill the Scholar Pledge can earn up to 4 years of tuition paid at a college here in the state of Indiana. That tuition amount varies based on the type of institution they go to, but it does cover portions of the tuition for them. There have been over 100,000 Hoosier students that are currently enrolled from 7th grade to college seniors, and then over 45,000 have actually earned a college degree through the scholarship. I am actually one of those recipients of the scholarship, so here I am standing in front of you today as a success story, I guess. Thank you. So a brief timeline, like I said, we opened in, we were created in 1990. I say we because I used to work for the commission, so it's hard to pull myself out of this mindset as well. But it was created in 1990. Over the course of the 30 years, there have been a lot of changes. Probably the most significant change has been the implementation of what's called the Scholar Success Program, which is a high school program where they have 12 different activities over the course of freshman through senior year of high school to help them get college ready and think about access to college. There is also a college version of that. Once they get to college, in order to continue to keep the scholarship, they have to meet specific requirements as well. And then the scholarship celebrated its 30th anniversary in 2020. The scholarship works. What we found, or what the commission has found, is about 4 in 10 high school graduates is financially eligible to be part of the scholarship program, but only 1 in 10 high school graduates is actually a scholar. And so the reason why we're here today is to see if there's a way to increase that number of eligible students who are actually activating the scholarship and using it once they get to school. There is a slight skew toward women making up a larger scale or share of that 21st Century Scholarship recipients as well. Again, the data show that scholars are more likely to go to college than other non-scholars, whether that is low-income peers or even higher income peers that they have. So you can see even in this slight downturn over the path from 2015 to 2019, 21st Century Scholars has continued to increase the enrollment rates in college, while others have been decreasing. So it has proven effectiveness in terms of accessing college. Now, once they get to college, there are still positive outcomes. It closes the gap between income levels for freshman year GPA. So if you look at the higher income or the higher GPAs on the right-hand side of this, you see that 21st Century Scholars are at or exceeding the GPAs of their higher income counterparts, peers, and then also low income peers who are not scholars, who are not access that program. Almost 3 in 4 students earn 30 college credits during their first year of college. This is really important because to reach an associate degree in the state of Indiana, you need 60 credit hours. To have a bachelor's degree, you need 120 credit hours. That was something that was passed into law a few years or about 10 years ago, requiring those specific numbers. And so in order to have an associate degree on time in 2 years, you have to take 30 credit hours a year, and 75% of scholars are actually reaching that number and staying on track to graduate on time. 21st Century Scholars has also improved the on-time completion at 4-year institutions. At 2-year institutions, it is good, but at 4 years, it's better. So you can see, again, it's just coming out higher than their low-income peers specifically. It is also closing the gap in that 2-year on-time completion rate. So one thing that happened in 2018 is the Commission for Higher Education and the Department of Child Services entered into a data share agreement that auto-enrolled all foster youth into the 21st Century Scholar Program. And this was actually a huge lift for the Commission and for DCS. But the goal of it was specifically to alleviate some of that focus on caseworkers so that they can focus on immediate needs, not specifically trying to enroll their young people in the scholarship program. But it also ensures that students weren't falling through the cracks, so that once a young person enters the foster care system, they're automatically set up to have this financial opportunity post-high school. So there has been a lot of success in that, and they actually, DCS and CHE just re-upped their data share agreement, for another 3 years last year. So they are seeing success in that. And so what we as a subcommittee are asking is that the commission will endorse the recommendation of the Commission for Higher Education to auto-enroll, students in 7th and 8th grade who are part of the free and reduced lunch program. There would still be additional requirements. They would have to accept the Scholar Pledge in order to actively be part of the program. But it relieves the barrier of the application process, which we've seen just as a couple of people have talked about access to internet, access to technology, understanding the application, all of these things have been barriers for students in 7th and 8th grade to actually access this, especially for their parents to help them access it. And so this just alleviates the barriers so that we can focus on other things once they get to high school to get them to college. And knowing that there's a financial opportunity on the other side also helps them to think about the possibility of going to college. That is a lot of information very quickly, but any questions that I can help answer?
Actually do that. So for eligible students, will the school be doing the application?
I don't know the exact process of how it would work. I believe what would most likely happen is that the Commission for Higher, if it's similar to what we've done or what they did for the foster care, is that the Commission for Higher Education would receive a list of all eligible students who are for free and reduced lunch, and then they would automatically enroll them that way.
And those are big numbers.
What are the numbers?
Those are big numbers.
They are big numbers, yes. And I was told by Josh Garrison, who's the Associate Commissioner for Policy at the Commission, that they are big numbers, but it is a 10 times return on investment per student in the state of Indiana. So the investment is about $1.7 billion that in return currently, and that's all for the numbers that we currently have. And so it's only going to grow if we get more young people into that.
Excellent. Well,
For those that you identify, do you have the foster numbers on hand as far as those you identified through I know a much smaller number?
I don't have those off the top of my
It'd
head.
be
That's like commission
Great to
thing.
have just in general.
Yeah, we can
So great.
definitely,
This is obviously a big build on top of that, but I think important. So thank you.
yeah.
any other questions? Great presentation. Is there a motion then that we approve the recommendation of implementing automatic enrollment in 21st Century Scholars Program for eligible students?
I'll make a motion.
All right, is there a second?
I'll
All right,
second.
And then all those in favor of, or any other discussion? All those in favor say aye.
Aye.
Opposed? All right, and then Julie, what we'll do is we'll send to the other members so we can get a quorum and get that done. Thank
Thank
you
you.
very much.
Thank you, Chair.
All right, our next presentation will be that's right, been bouncing. We'll have, yes, Janae Hanger, Children's Policy and Law Initiative, and Sandy Runkle, Prevent Child Abuse in Indiana, presentation on the developmental case for a delinquency age 4. Nice to see you again, Janae and Sandy.
I should say it's nice to see you too, Justice. Sorry about that. I'm just going to open with a few remarks. I thank the commission for hearing this presentation. First of all, we are basically making this presentation on behalf of the Juvenile Justice and Cross Systems Youth Task Force. I'd like to point out that there are a couple of people not here that were very instrumental in preparing this PowerPoint and presentation and actually doing the research that we did, the extensive research that we did on best practices across the country. And that would be Caden Posiask, who is listed on the PowerPoint. He couldn't be here today because he's second chairing in Monroe County in the prosecutor's office, and he's getting ready to graduate from law school. So Kara Boyles also contributed to this presentation, so we want to make sure to reflect that. In addition, I would like to point out, we have a subcommittee. Sandy and I actually co-chair the subcommittee. It's Objective 8. And if I could go ahead and start the PowerPoint.
It's on page 28 on our materials.
Thank you.
28.
There should be a
It's,
little.
it says 56 under the slide, but it's 20 lower right hand side.
Oh, thank you, because I need to read the objective. Okay, so anyway, objective 8, we co-chair that subcommittee. I just want to point out who sat on it. Amy Carrozas, Dr. Roberta Hibbard, Dr. Shannon Thompson, Robert Pinkey, and then of course, we had our interns that helped staff some of the research. I'd like to point out a couple, well, the objective itself says identify and encourage adoption of effective and promising practices and policies that integrate the science of child and adolescent development into the juvenile justice system's response to children. I'd like to point out a couple things. One, this presentation is informational only. We're not making a specific recommendation to the commission at this time. Two, it's important for all stakeholders to weigh into this. And as a part of this process, we spent probably the last 3 or 4 months reaching out to various stakeholders, including the Juvenile Justice Improvement Committee. We have in our plans to meet with the Prosecuting Attorney Council, and we will continue to meet with stakeholders to discuss these kinds of issues. I want to just make a couple of observations before I turn it over to Sandy. She's going to open up our presentation. First, currently, there is no minimum age for juvenile court jurisdiction in the state of Indiana. Second, we are trying very young children, and this is not a developmentally appropriate practice. Third, doing so risks negative long-term consequences and increases the likelihood of future involvement in our juvenile justice system. And finally, making a change here and addressing this issue can actually bolster alternative community-based pathways, benefiting the child and public safety. So at this point, I'd
Just add
like
something.
Mhm.
The Supreme Court goes around the state and we talk to judges from around the state, and this was one of the main issues for them. And some of the judges said they'd love to have something like at Kings Island, where you've got to be this tall to go to detention because they're so young that are being arrested and coming into court. So I just want to share that with the commission, that it is one of the major issues that the juvenile judges presented to the court this year.
Thank you. And I want to turn it over to Sandy now.
Thank you so much. So I'm going to take just a moment to talk about the importance of addressing this issue in relation to a child's development. As I'm sure you're all aware, a child's brain is not fully developed, especially in relation to impulse and critical thinking skills. So their ability to meaningfully, actually, there we go. So their ability to meaningfully understand and participate in legal proceedings, that's really limited. In fact, I'm sure you'd all agree that there's some adults that, don't always understand those proceedings. If you add to that the probability that a child has also experienced some type of trauma, then that can hinder the development of those parts of the brain even more. So a child who is perhaps 12, 13, 14 years old, they actually could have, the cognitive development of a child much younger. So it's imperative then that we serve children and provide them with the appropriate resources. So let's have that underdeveloped brain sort of work for us, work in our favor. So with services, we can mitigate some of that trauma, and we can help to create some positive changes in the brain and the behavior, because treatment can be so effective during that time. So if we're saying that trauma can impact the brain negatively, then positive treatment and resources can impact that brain in a positive way. So if a child does experience that early system involvement, as Janae referenced, it actually increases the likelihood of future involvement. And if it's a child who's experienced trauma, then it's really like piling on, trauma after trauma. So being able to then treat and provide those resources and be able to mitigate sadly, that can become a little bit more challenging, if that trauma is continually piling on. So as you can see, many system-involved youth already are struggling with mental or emotional health issues. And in some instances, we're also dealing with co-occurring issues. So, as I referenced before, trauma can have a tremendous impact on development and behavior. And you can see that many youth in the juvenile justice system are already or have already experienced some of that trauma. So thank you. And with that, I'm going to turn it back over to my colleague.
Thank you, Sandy. All right. Well, first of all, we want to point out that trying younger children compounds racial disparities in our juvenile justice system. I've worked with a lot of people on the commission, and we all recognize that there is disproportionality in our juvenile justice system. If you capture the data on the screen, 2 in 4 Hoosier youth in the justice system are kids of color. This is actually reflected in our school system as well as far as school discipline. And we think that one of the catalysts for entries, such early entry into the juvenile justice system is school discipline. And we need to ask the question, where are these referrals coming from for such young children? So ultimately, if we don't get back to the referral source and start addressing these issues and ensuring that children stay in our community, we are actually feeding disproportionality in our juvenile justice system. Well, we know that early system involvement is a problem for children. And I want to point back to what Sandy was saying about trauma. If you look at some of the data for children who are actually in the juvenile justice system, they have very high rates of trauma. And for us to be putting children under the age of 12, we risk all the things that we risk with older children. We risk future system involvement, the collateral consequences of a delinquency record, school failure, barriers to employment and lifelong success. There are national trends around this issue. We did extensive research on who is doing what across the country and what organizations have what positions. And as you can see, there's a growing list of organizations that have come forward and say, we really have to stop this practice of putting children in the juvenile justice system that are very young ages. You've got the American Academy of Pediatrics, the American Psychological Association, just to name a few. There is a trend legislatively across the country. So far, 7 states have adopted a minimum age. Best practice research indicates that at age is usually around 12, 13, or 14. We were able to look extensively at several of these states to at least bring it to your attention what other states are doing. In Massachusetts, this is one state that just recently adopted an age of 12. It was part of a comprehensive juvenile justice reform bill. It involved, it basically had, a line drawn in the sand as far as the age, minimum age is concerned. It had no exceptions or discretion. And it was part of a comprehensive reform bill that created an oversight board that would monitor the progress. They have issued one annual report that indicates that they are meeting their objectives that they had sought by passing the legislation in the first place. New York is another area we might want to look at too. This is an area that took a different approach. It has a deferential response program, and it was created by their Office of Child and Family Services. It was more of a regulatory, interagency collaboration that developed a program that they were able to share with their district level offices to basically have a differential response. It's one way that we can think about trying to level the resources for areas that geographically have less resources than other areas. California is another area to look at. Their approach was more county-based. They basically developed a comprehensive guide, and asked their counties to do an assessment of their services locally and come up with a plan that they would implement to basically respond to children who touch the system or were about to touch the system to defer them into community-based care. I want to take a minute just to step back and reflect on who we're seeing in the juvenile justice system in the first place. We know that in the juvenile justice system, a vast majority of the cases that are coming in overall are status offenses and misdemeanors. If you look at the data for the underage, the 12 and underage population, you see this mirrored. And there's almost 87% of the children come in on status or misdemeanors. So the question we have to ask at that point is, and then you look at how many petitions are filed and actually adjudicated. It's a waste of system resources and it has negative impacts on very young children. So I want to ask the question, why?
Can I
Why
ask,
are these
can I ask a
children coming
question,
in?
just
Sure.
back to the
Absolutely.
earlier slide on the other states?
Absolutely.
Do the other states that have set a floor, do they delineate between offenses on whether misdemeanor or felony, or do they draw a hard floor? And then
Back to the other states like
the
California.
six or seven that you mentioned.
Right,
Yeah.
they all do it differently, and I should have pointed that out. We did provide you with a table of the statutes for those states, and you
Oh,
can check
sorry.
them out yourself. Some of them carve out exceptions for the preteen ages for the most serious offenses. Like Massachusetts, I believe, does not. And so that is something we need to consider here in the state of.
I'll look at that. I figured that they did, but
Yeah.
Okay.
So again, that is something we need to consider here. Okay, asking the question of why children come in the first place, we have to go back to what is happening in our community. I think one point, if you can draw any point from this presentation is that schools are an important access point for families to access services. That doesn't mean they're always going to get the services, but it is something that every county has and every community has. And what we have found through a 2018 Department of Education assessment is that we lag way behind in our state on the national benchmarks for staff to student ratios. And I want to point our attention to, I mean, school counselors obviously were double the national recommendation. School social workers, and those would be for the kids with the highest needs, it's 4,639 to 1. School psychologists, again, these are the people that provide us with the best practices around competencies that can address issues for children in school so that we can emphasize prevention and early intervention. Since that assessment was done, there hasn't been, we know there's been a pandemic, and we know that actually the need has accelerated as opposed to decline. I want to point out, so we know that there's a gap in resources in a really fundamental aspect of our infrastructure in the state. And so I want to talk about just a little bit about what we can do. It's not a matter of just throwing more money at services. There's a lot of different things we need to consider in order to bolster the alternative pathways. One, for schools, we've got obviously kind of a windfall right now from the pandemic. The schools have $3 billion that they were given from the federal government to help address the pandemic's issues over a 3-year period. What we found from research is that only 17.1% of this amount, and not the whole amount, they haven't spent the whole amount. It's been $2 billion is still left there as of this summer, and only 17.1% has been devoted to student services supports professionals. The other point I want to point out is the Medicaid reimbursement. This was legislation, House Enrolled Act 1450, that was just passed in, I believe, 2021. And this legislation helps free up money for schools that they used to devote to special education services and other kinds for 504 plans, behavioral interventions, and other kind of individual healthcare plans. And so the idea is because we now can actually get reimbursement for Medicaid expenses that cover a lot of these expenses, schools now are in a position to bolster the professional staff that they need to develop competencies in their school community. We also have to look at the community resources that have increased over time. And we know that we have resources in the groundwork to really move along in this direction. We just need to have stronger collaboration. There may be funding issues in some communities, but there are things in place that can address both the high needs, the children with high needs, and those children that we believe need extra attention because of public safety issues. So let's talk about important considerations. I think there's 4 important considerations we really should think about as we move forward. What should the statutory minimum age for juvenile court jurisdiction be? How can we increase existing school and community services as alternative pathways for children under the statutory age? How can we increase comprehensive support services in Indiana schools? And how can we monitor the long-term outcomes resulting from minimum age legislation? And finally, I think I put two questions into one box, which is what are the next steps? First, what should be a minimum age? I think we need to seriously look at 12. Some states have adopted discretionary jurisdiction for preteen ages for the most violent offenses. Those are statutes we can learn from and their experiences as they have done that. And I think if you do make that kind of discretionary jurisdiction for minimum age legislation, we need to link it to competency to stand trial. Because we know, because of the research, that a child's brain is not capable of understanding the very complex concepts that we have basically required them to do when they have a case filed in the juvenile justice system. So how can we use school and community resources as alternative pathways? Well, first, we need to emphasize by looking at, comprehensive student supports and community-based approaches to issues with children with high needs, we really are able to emphasize prevention and early intervention. And so by adding school counselors, social workers, psychologists, we really are starting to develop that competency. Finally, we need to make sure that we're recognizing that we have things in place that actually can help those children with higher needs. How can we increase comprehensive support services in schools? I mentioned before, we can't just throw money at it. We have to address systemic workforce development issues. And we need to engage the professional associations as we have that dialogue. We need to reduce access barriers to existing community mental health resources. And there are barriers, even for, some of the programs that exist within GMHA and DCS, they require diagnoses of 2 disorders. There's also limitations around Medicaid that we really need to grapple with. How can we monitor long-term outcomes resulting from the minimum age legislation? I think these are a couple of ways we offer that might address that. What are the next steps? I think we have to find consensus on this issue. Stakeholders, including legislators, law enforcement, service providers, judges, and advocates, should come together to address these issues. We encourage the commission to stay engaged in it. We think that emphasizing student services as an important access site for families and children has to be a priority for the state. And we need to improve collaboration among schools and those service providers and regulatory agencies to make sure we're getting those fundamental and increasingly important services to children through the schools community. And finally, we need to encourage resource mapping and use of 211 at the county level so that we can have a common understanding and access to community resources. So if you want to find out more about this, there was a webinar. I think you should definitely check it out. It was very powerful. Lisa Pettis from the R Street Institute, that's a national organization that's very concerned about criminal justice reform. Lindsay Gross-Nickel, who's a prosecutor from Whitley County, and Josh Rodner from the Sentencing Project, along with Jennifer Willard, who's the professor of psychology at Georgetown University. They had a very, powerful discussion about what the issues are confronting our state and what the resources are to help address it. Finally, we have more information on this issue if you'd like it. It goes a lot deeper into these issues. We're offering resources through our PowerPoint. You've got the California guide that gives you some insights about California. Massachusetts, their report, and then you have the state by state statutes. I would like to just say in final, and I invite Sandy to share with me. Okay, so in final, I'd like to say this is achievable and it is within sight. We've been working on juvenile justice reform in the state of Indiana for over at least 20 years that I've been doing it. I know we've been working on it for a long time. And I just, all of the reform that we are doing is actually creating the groundwork for this right now. It is time. The CSG, the Council of State Governments, and the Juvenile Justice Reform Task Force collected data and shows that we have a problem in this state. Annually, there are many children going into our juvenile justice system that are under the age of 12. It's time we act. Are there any questions?
You know, I would add with our next step to also look at, you talked about 211, but look at 988 as we roll out 988. And if we look at there being a surcharge, that's really an avenue with regard to someone to call, somewhere and answer somewhere to, with regard to crisis. intervention.
Absolutely.
I've just talked to Senator Donato, is the legislature looking at this? Do you know if there's any bills talking about this?
I do know, we have talked to a few legislators, and I'm not talking to the Commission of the Juvenile Justice, and Cross System Task Force, but I have personally, and there are other people that have been talking to legislators, and they're very concerned. I mean, there's some concern there, and I do expect that there might be legislation proposed. If not this session, I'm sure that we'll probably see something in the next 2 years.
Yes,
May I ask a question?
yes, Representative Summers, you may.
That was my question. Do you have suggestions for legislation? Because our deadline is Friday.
Excuse me. This mic's really too-
Doesn't CSG have some model legislation? Isn't there some model legislation out there?
I'm sorry?
Isn't there model legislation to follow up on Representative Summers? Isn't there? Could you provide her with model legislation?
Well, we've got what other states are doing. I think part of the issue is bringing everybody together to have consensus around it. We actually presented to the Juvenile Justice Improvement Committee, and they're worried about that one or two cases where they don't know how to react to that situation. And they want to make sure that they're protecting the public safety and also addressing the needs of children. So that they're, it's under the power of the board. And so I think there's a lot of the juvenile court judges, I think, need some comfort level that their issues are being addressed. And I think that we can get there. The data says that there's such a large number of children that shouldn't even be hitting our system in the first place. So let's look at that. Let's look at what we're really concerned about and have that dialogue. I don't think it's that complicated to do. We just need to come to terms with what it is we want to see happen. We have the statutes from other states that we can look at. The ABA has taken a position on, this issue.
No,
I'm
but
sure that can help.
CSG quite often has model legislation.
Right.
You've not seen model. I'm not.
I
talking
have
to-
not seen model legislation.
You may want to look at
ABA,
that. There may be.
but we could look at that.
This CSG is this week. They're in a while.
Any other questions?
I have a question. Great presentation, by the way. Thank you very much. Can you tell me slide 63, where you've got the school counselors, social workers, psychologists, and school nurses, where that data came from?
Sure. It was that 2018 assessment. I can send it to the commission
Assessment
like to
done
see it.
by,
by DOE, Department of Education. In matter of fact, one of the things that we think needs to be redone is another assessment to see where we're at. We have, done some research on this, and we have found out that there haven't been any follow-up recommendations to the legislature since that assessment was done. And so we know things have changed over the last 4 years because of the pandemic. There was just an article in the Washington Post, and I'd love to send that to the commission. It woke me up in the middle of the night and I was reading it about our deepening crisis across the country and teen suicide and depression. And so I think we're at a pivotal point in time where we really have to start, lining up our resources that we've worked so hard to do over the last decade or two and make a collaborative, interlocking network of services around children and families.
I would concur with that. I will say that I've been trying for over a year to get the number of school nurses per student in the state of Indiana, and we are literally calling every school to find out, do you have access to a school nurse? And if so, you know, how many hours is she there? And the other thing I'll say along the mental health lines is with the Youth Risk Behavior Survey, and I know I've said this here before, but 11.8% of our 9th through 12th graders said they had attempted suicide in the prior year.
It's
Now, that is going to translate into substance use disorders and risky behaviors and a lot of other things that will land them right in our justice system and our correction system.
This, in my opinion, this is a pivotal piece that we just have not focused on enough. Excuse me.
Janae, are you on the committee, the legislative committee, the oversight committee that Steve David is, Justice David is? It'd be interesting to, and that's dealing with delinquency, putting that recommendation to them. You may want to get a hold of Justice David. He's chairing that. There's different subcommittees. There's a website, I think, up.
Sure, absolutely.
Where are you on that?
I'm on the screening and assessment work group.
Is that issue? Because I'd love to have that issue looked at. So maybe you could bring it, because screening, would that be a screening issue?
I think we're looking at more like actuarial tools of assessing risk.
Okay.
Chief Justice Rush,
You're on it.
well, I go to it. The forerunner of that group, the Juvenile Justice Reform Task Force that this group created a couple years ago that worked with CSG, considered this as one of their recommendations. It didn't get consensus, but they did get consensus, and it's in 1359 to not have children detained below the age of 12. So we now have a bar on secure detention of kids under 12. There are a couple exceptions, but there was not consensus on minimum age for delinquency jurisdiction at the age of 12 at that time. So I think what Janae is saying is there's still some more work to get there to that consensus point.
Are any of these funds going to extracurricular activities for the youth?
Are there any what? I'm sorry.
Any of these funds going towards extracurricular activities for the youth? And the only reason I say that is because there's a non-for-profit here. They are called Voices, and she worked, the owner of the non-for-profit, she worked in schools, and she was saying that she saw like an increase in, you know, students that were getting in trouble and, you know, going to probation and everything. And she sort of focused in on them and, you know, just started art with them. And she was just saying that it really gave a lot of them like a platform to express themselves in ways that maybe they weren't able to at home. And even looking at it a little deeper, she was saying that a lot of these youth were going through things at home, and, you know, that showed in their schooling. So are any of these funds like?
I can't answer that specifically. I actually had one of our law interns do the research on this, but I can tell you that makes sense. We know that we need to focus on building relationships with children in schools, and this professional staff can help us get there so that we keep kids in schools. Mentoring relationships are really important for children who are high need. And of course, any activity that would allow them to build those kinds of relationships is going to help. I just can't answer specifically.
Any other questions? We need to keep moving on this. We need to keep.
Thank you.
So anywhere that you see that the commission can plug in on this issue, we need to keep moving. Even if we can get consensus on misdemeanors and status,
Right.
would be 80% or
Right.
87% of the cases. Okay.
I agree. All right. Thank you.
Thank you.
Julie, we're up to your portion of the agenda.
Okay, so just a few quick things. Strategic planning is underway. What will be in your strategic plan when you get the draft of it will be some new or refreshed strategic goals and objectives. So you can expect, you know, some things will carry over that are in the current plan. There will probably be some new ones and some things that are dropped. So working on all of that. We talked today about having the fetal alcohol spectrum disorder stay in the strategic plan as an objective. So I'm still kind of taking input and working on refining those strategic goals and objectives for the next draft. And then based on that, we'll look at whether we need to have any revisions to our task force and committee structure to make sure those are aligned, right? So we have, just like we do currently, a task force assigned for each strategic goal area. So we'll see if we need to make any changes to those. And then we want to look at two kind of more functional issues with the commission. One is how we get more youth and family engagement in all of the commission work groups, not just here at the commission table, which has been fantastic, but through the rest of the work groups as well. So Blaine Cook, the commission intern, is working on some recommendations for that we'd like to fold into that strategic plan for you in February. And then we're also looking at a state to local communication plan. How do we get information out from the commission to local communities? How do we get information from local communities to the commission? Kind of break the indie bubble and get a little bit more communication statewide. So those are the items that we're looking at, including in the strategic plan. The timeline, we did hold a strategic planning retreat on November 7th. Several commission members attended, as well as some of our task force and committee co-chairs. So we had a good group, probably about a dozen people, really kind of break down and look at those content elements above and have a good discussion. So the draft is in progress. I'm kind of working on processing all that information, some survey information I got to kind of boil it down into a draft. So we will get that draft out to you. My hope is before the holiday break, but if not, then hopefully early in January, to have some review and feedback, final review in February, and then ready for your adoption at the February commission meeting. There will be an executive committee meeting in January where we'll have a good draft for the executive committee to look at as well. So that's where we're at with strategic planning. Any questions?
Julia, I just want to mention, and Kate Shadell is here and she could speak to this, but we did bring together a group of youth for actual consultative purposes at the Indiana Department of Health and actually pay them a stipend to be engaged. We had 250 applications or something for I don't know how many spots. So that would be a resource that would be available for the Children's Commission to already work with.
Yes.
I don't think that we, Kate, involve families like parents and other people.
Thank you for that. Yeah, that's definitely one of the angles that we're looking at. You know, when we think about youth engagement in the commission, we know that there are already several youth groups out there. So do we draw on the ones that we already have? Do we create a new one? So we're trying to look at different ways to structure that. But yeah, that's such an impressive group that you have together. We know we have Foster Success advising DCS. I think there are some other agencies that have youth advisory groups as well. So yeah, we're looking at how do we make the most of the youth input that we already have.
Seems like
throughout the state.
bringing together sections of each of those groups might be great because they'll
Yeah.
all have a health directive or a DCS directive, or
Right.
something that they work from.
And we do have funding from Casey. Well, we will have hopefully for calendar 2023 funding from Casey Family Programs to do another youth summit next year. And that's the idea, is to bring together those existing youth and family advisory groups in an event to kind of a broad-based kind of looking at all the areas of the commission and looking at from the youth and family perspective, prevention. What could we have had in place to prevent these youth and families from even getting in need of state systems?
Do you know if we can use any of the Casey grants to give stipends to our youth experts? I like
I'm
the
sorry.
fact Health is talking, you offer a stipend.
Mhm.
Can any of the can we get a grant?
I think that's,
Casey or
that's
something?
part of that would be part of the budget for that, for sure,
All right.
would be to compensate people for their time and involved in both planning it and then ideally attending.
Not
it.
just the summit, I'm just talking for youth representatives.
Yeah,
on
yeah.
different Commission committees.
Yes.
Okay.
Well, yeah, and some of that, there's, for the commission itself, it's already in statute, and so we are compensating our youth members as is required by law for.
Thank you.
So yeah, we need to look at that that'll be part of the recommendation as well. Yeah, for additional youth engagement. And then just a couple of implementation updates, as we've been doing for the last several meetings, kind of reaching back to things that the commission has approved in the past and seeing where we're at with them. So we have had a couple of different sets of recommendations come through the commission for streamlining licensing for different behavioral health professions. Back in 2018, we had some recommendations regarding licensing for clinical social workers, marriage and family therapists, and mental health counselors. So I know not all of you have been around here since 2018. It had to do with internship hours and supervision and just kind of trying to remove some barriers there. And then I think about 2 years ago, we had some recommendations related to licensing for clinical addiction counselors. And again, kind of a little bit of a streamline because we know that there are folks in, let's say, a Master of Social Work program who might become a licensed social worker and with not much addition to their training could also qualify for a clinical addiction counseling license. And so there were some adjustments made to that in the 2021 legislative session. So as it happens, what does PLA stand for? Public Licensing Agency? I forget what the Professional Licensing Agency, and the Bowen Center at IU just put out Indiana's Health Workforce Report. I didn't print it because it's a lot of pages, but it's linked on the website. That has kind of an update of where we're at with all our licensed health professions. I pulled out in this chart on the slide, just those behavioral health professions that the commission has had recommendations on. And the ones that are highlighted are kind of the years after the commission took action. And basically what you see in this chart is we've basically kind of had a steady increase on all of them. You don't see like a major bump after the legislation. So it's kind of hard to tell whether that had any impact or not. We are generally increasing in our numbers of licensed behavioral health providers. But, you know, everyone across the state will say it's still not enough, right? We still need a lot more. And just a note on this data, these are currently active licenses, but that doesn't necessarily mean they're practicing. And in that report, they break that down further of like out of those people with license, they ask them, are you actively practicing in Indiana? And that's a smaller number. A couple other quick updates. So we had, I don't remember what year it was, 2019 or 2020, maybe, the commission approved a set of definitions related to trauma and adversity and what it means to be trauma informed. Dr. Box, you mentioned the YRBS, and I know that they have incorporated the ACEs questions into YRBS. And so I was on the last work group for that. And we talked about, you know, how to make sure that the YRBS is administered in a trauma-informed way, right? Since we're asking questions about trauma. So I was able to provide that definition document to your team, you know, your staff member who's of course new at IDOH and probably didn't know that that was there. So I'm continuing to try to get these resources into the hands of people who are working on related issues within the state. It's always an ongoing challenge, right? Because we have new professionals all the time. So trying to make sure that folks who get onboarded in new positions across state agencies that are dealing with children, that they're aware of the commission, they're aware of the resources that we have, and you know that they're making use of those as they relate to their program area.
Julie, for your engagement.
Yeah, absolutely. And then just recently, a couple meetings ago, you all approved some recommendations related to evidence-based youth violence prevention and intervention programs. And serendipitously, this kind of stuff seems to happen all the time. I got a survey from the Marion County Commission on Youth related to youth violence programs. So I said, let's see what kind of questions they're asking. And I happened to be able to put into that survey, the commission just approved these 3 specific, you know, interventions. They're evidence-based. Here's a link. And then I later ran into somebody from McCoy who said, we were so happy to get that information. And now we can use that as we plan violence intervention in Indianapolis. So it's good to know that those 3 interventions are kind of, you know, state approved or endorsed because they're evidence-based. So, you know, sometimes we're able to kind of close loops like that, have those conversations. It's a little bit hard to document, but when it happens and I can document it, I'm going to document it for you. So you can see how your work is getting out into the community and into different state agencies. I think that's all I've got on implementation updates for this one. Just a reminder of the 2023 commission meeting dates. We're sticking with the 3rd. I think those are all the 3rd Wednesday of the month, 10 to 12. Senator Donato will be chairing next year. We are moving back over to Government Center South at your request. It's not as pretty, but the acoustics I think are better, and it's much easier for the AV team that helps us with the webcasting and the microphones and everything. So we'll be back over in Government Center South next year.
And it helps us to move from the State House.
It's a little more
We
convenient.
have
Yeah.
session on
Yeah.
2 of your dates.
I know. I know. Yeah, those commission meetings during session are always challenging, but they're also really good touch points to know, you know, what's going on in the session and how we can support each other's work for kids during that time. That's what I've got.
Well, Julie, I want to say this is my last time cheering, and I want to thank you enough. As you know, Julie will be moving on. But you always want to leave a job better than when you started and you've taken it to the stratosphere. You've been excellent. And I think Julie will continue to be involved in her new job. You'll be here in February. She'll help us with transition. We have posted. I asked Julie to send a copy of the job description out, but what outstanding work. And she's done such a great job working within sort of the court structure, communications, CASA program. So she has sort of embedding this position within the children's issues. It has been, you're a valuable member of that team, and you probably don't see all the other things I see that she does, and she's appearing and she's advocating on behalf of this. And I thank you. I mean, I know you'll be here in February, but it's my last time chairing. I so appreciate all you've done.
Thank you.
And if you want to hear a little bit about it, you may want to come to State of the Judiciary this year, where I may be mentioning Julie Whitman and the work she's done with the Children's Commission. Anything else today? There's a reception afterwards.
Oh, yes, sorry, I forgot about that. Yeah, everyone who's here is welcome to join us just right over there in the author's room for lunch upon adjournment of this meeting.
If there's nothing further, we're adjourned. Thank you. Julie, I have those certificates. All right. You're in it.